call Jacinda Ardern.
Thank you, Mr Speaker. Always a pleasure to follow on from Simon Bridges, who called, I believe, this bill a worthy bill. And he's probably the only person in Parliament, I think, who could actually patronise a piece of legislation in such a way. But before I begin, Mr Chair, there were three things that came through strongly for me that this bill was trying to achieve. Some had a greater focus than others, but one is obviously the extension of protection to children who are victims of domestic violence. One other element, to a certain degree, I believe, was expediency, and the third was fulfilling our international obligations, although that wasn't the only catalyst, I think, for the sensible provisions that were contained in the bill. But in each of those areas, it's still my view and the view of Labour that we could have gone further under each of those headings, and I want to touch on them quickly. But before I do, I want to say a quick point around children generally coming through our justice system, whether it be under the provisions of legislation such as this, or as witnesses through our family courts or our criminal courts, that it's becoming more and more obvious through work by academics that our justice system does take too long when dealing with young people in whatever facet as a victim or a witness in the way that it deals with them. That it's incredibly important that we process children through our justice system as rapidly as possible for lots of reasons. If they're a witness, it's due to their ability to remember a particular circumstance. If it's as a victim of domestic violence, it's for obvious reasons that that's obviously a traumatic thing. And under that heading, I absolutely endorse anything we can do to speed up that process, and there are elements of this bill which do. But at the same time, there are things that have been passed in the past around the use of judicial officers in the family court which also could speed up that process where children are involved. And I would really implore that the government take up that opportunity. It already exists in legislation, and it's something that they could pick up tomorrow if they chose to, but I believe it's currently not a priority. The second thing, a quick point I'd like to make, is that when it comes to domestic violence legislation, I do think this House has a tendency to implement and forget, and that's a very natural thing. We're legislators, and often we rely on those on the ground to implement policy which churns out through this process. But when it comes to domestic violence legislation in particular, I have heard reports of recent domestic violence legislation this very committee has been involved in, including the police safety orders, that may not have, which may not be working in the way in which Parliament intended. So I guess I'd like to add to the record my hope that for such pieces of legislation, perhaps in future select committees, and including for this one, could review the way they're working on the ground, perhaps in 12 months' time, because if indeed they are not performing in the way we intended, if victims are not being protected, and children in particular are not being protected in the way we intended, that is something that Parliament should be involved in reviewing. And that indeed goes for the police safety orders if the reports I'm hearing are anything to go by. Focusing specifically on those elements I've touched on, the protection, the expediency and the international obligations, I want to touch on some of the points that the Minister made. Obviously, he pointed to the fact that this bill was about extending the protection for children. And the Select Committee, I think, honed in on that point when it considered amending Clause 6.2, because, of course, when the bill came to us, protection orders which covered children were set to expire by virtue of their age rather than their circumstance and rather than their family circumstance. And I think the Select Committee rightly considered that and said that instead we felt it was important that the period be extended to the time period of which a young person is resident in the home of the person who has originally made an application for a protection order, and I think that's right. But I also think we should have gone a step further. And if the Minister is correct in stating that this is about protecting young people and children, I would hope that the government would vote with us on this, because we have put an SOP up in this regard. Our view was that once you leave a residence, and you are a young person even beyond the age of 17, you are in fact more, Mr. Chair.
Jacinda Ardern.
Thank you. You are in fact more vulnerable than you are perhaps when you are still in the home of your family member. It could be that, for instance, you're going out into an independent living situation, and that in fact there is very little harm to empowering that young person to say, you are currently covered by a protection order. If you choose not to be, you may opt out at any time. In fact, that feeds into this idea of expediency and efficiency, which I would have thought that the government would have also supported. So our preference was an opt-out situation that wasn't bound by age or circumstance, but simply left that option up to the young person. And I see very little harm from such a provision, and a lot of things that sit in favour of operating the system in that way. So I'd implore the Minister to speak to that point particularly and tell me why the government does not support that. If, however, we do remain with a circumstance where the government wants to stick with the with age-based provisions, we would also like to see the definition of a young person changed, because of course one element of this bill is our international obligations. Very good that we're picking up on the optional protocol, but disappointing that the founding document, the United Nations Convention on the Rights of the Child, continues to be neglected at its very core, and that is the point at which New Zealand continues to treat the definition of a young person. Now, I know that all the politics sits around the idea of the criminal age of responsibility, but it's something that we continue to contend. There are enough elements of our legislation now which gives flexibility to the courts to deal appropriately with the severity of an offence, and that we should now move to increasing the age to 18 and fulfil our obligations under UNCROC. This would be a prime time to do it. That's why I'm giving the government that option by putting forward a supplementary order paper in which they can change the definition. And it would be a bit of a saving grace, because I imagine the government will be coming up for its review as to how it's fulfilling its obligations under UNCROC very, very soon. And there is no doubt that obviously this will be a point where the committee will be asking the government questions on the at an international platform, and this will provide the opportunity for the government to rectify that wrong. And it will have many positive spin-offs, not just for this piece of legislation and widening the protection for children and young people, but in other areas where we currently have gaps in our service provision for care and protection issues for young people. So I implore the government to take up that fine wee opportunity. The Minister also talked about the way in which the processing of orders. And again, that would have been another opportunity to pick up something that the family court judges have raised with us, and this is actually their inability to really enforce some of the orders that are being issued by the court. So again, that's something that I would have hoped that the government would have taken up the opportunity to give greater powers in that regard, because in some cases we are seeing those provisions being flouted directly, and the family court has brought that to our attention, and this was an opportunity to rectify that. And also, I do want to also bring to the attention of the House the fact that time and time again when we come up with domestic violence legislation such as this, we really do hear quite personal stories of women and families who do not feel are adequately provided with the information required to understand the process they're going through, to understand the protections they do and don't receive through our domestic violence legislation. And there are two ways I think that we could have also improved that through this legislation. One was allowing or giving the ability of applicants to attend information sessions so that they could make better use of the protection orders that are being issued. And that comes right to the core of safety for them and their children in many cases. Also, adding a provision which would have required any judge who declines a without notice application, which of course would be in extraordinary circumstances, for at least written reasons to be given to the applicant as to why that has been declined, because that gives the applicant an ability to determine whether or not they will go ahead and proceed on notice with a protection order. Now, if this bill was about processing quickly and giving greater certainty to victims and to families. That would have been a sensible provision to have included.